Hey everyone, Harry here to talk about what happens now in the wake of the Supreme Court opinion generally precluding lower district courts from entering nationwide injunctions. And I've written about it in Substack. We've talked about it. It is something of a body blow. On the other hand, there are potential workarounds and no lack of attorneys wanting to work around it and already have plunged in. So that's the first point. The second point is on the very lawsuit itself, the birthright citizenship lawsuit. You had within 24 hours of the Supreme Court ruling a whole new complaint filed in the District of Maryland, making the same legal claims, but doing it on behalf of an asserted class. And in other words, making it into a class action. That is perhaps the primary strategy that litigants are now going to undertake. Because in the past, in the last several months, again and again and again, Trump issues an unconstitutional order. People storm into court and the district courts say, my God, that's like crazy unconstitutional. And at least in some instances, they enter a nationwide injunction. That's off the table now. So what is on the table? So the first possibility that people will now be turning to are class actions. Under the rules of civil rules of procedure, there is, and this is a relatively new development, say, 50, 60 years old, such a thing as a class action. Federal Rule Civil Procedure 23 governs it. And it basically says if you've got the kind of case that the relief would go to, or not really the relief, the injury is held in common by 100, 300, 10,000, more than 10,000, you can make those a class and bring it on behalf of the class. And that's a way that, well, among other things, some lawyers have gotten really rich. But you can see it makes sense if everybody, let's say birthright citizenship, right? You have your client, but really anyone who is subject to Trump's birthright citizenship order, which is nasty and lawless as more or less anything they've done, just completely crazy and malicious. But anyone who could be essentially any child of people who came here illegally, that's whom the Trump administration is asserting are not citizens, notwithstanding the clear language of the 14th Amendment. So you can have a class that encompasses all of them, or a little bit less, because the Trump administration is saying in the first instance will go only after people, both of whose parents came here illegally. So that's your class. And now it's pretty similar from the point of view of the district court, how you adjudicate it. But at the end of the day, instead of saying, I find that the claim in front of me by this one person or 10 people is valid, and I'm going to enjoin the government from doing it as to everyone. Instead, I find that this claim is valid as to everyone, which is part of the class, and therefore to grant complete relief, which the Supreme Court has said I can and must do. I enter that relief as to everyone, and you think of it as the same difference. And in a way it is, but. So point one is people are assuming that district courts will be open to recognizing class actions. And indeed, they have in trying to deal with Trump's lawless orders to date recognized putative class actions. That is to say, they haven't gone through all the hoops, but they've done it as part and parcel of granting relief. But Rule 23 says you've got to find this, 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 and this. And the first one is so-called commonality. So you have to show that all the people in your proposed class are really have basically the same claim. They're in the same position. And some courts are tougher on that than others. And indeed, the U.S. Supreme Court has been fairly hostile to class actions in recent years. And the question remains, in the wake of its decision Friday, will it loosen up? But you could find people saying, we'll just turn around and institute a class action. Courts saying, oh, no, you won't, or maybe you won't. Now, of course, what is the alternative to a class action, given the instructions of the Supreme Court that individual district courts can't grant nationwide injunctions? File 94 separate. That's how many districts are in the country, and each district can file relief within the district. 94 different individual actions. I mean, what this leads to is a total, sort of bedlam and inefficiency within the federal courts, and the real possibility of patchwork determinations. That's different in Montana from North Carolina, from Texas, from California. But that's the idea. If the class action, and so a separate strategy. Here, I want to tell you about 3 strategies that litigants are going to be undertaking now. So the first and most important, and the one that's already been launched, make the big cases into class actions, and then automatically relief for the class is tantamount to a nationwide injunction. Second, just blitz the country with a carpet bomb every single district. Supreme Court kind of asked for it with individual causes of action. Of course, that basically invites the same kind of patchwork set of determinations that you're worried about, given what the court has done. And there'll be some cases that you lose, and there's the real possibility of separate determinations and the like. And then the third that the court at least has left room for, and we will see playing out in some ways, some people will sort of stay the course but say, you need nationwide relief in order to get nationwide order in order to provide complete relief to the plaintiffs before you, because that is what the Supreme Court said courts can do. And there's going to be certain causes of action, like birthright citizenship, say, where you can say, you declare as to me that is invalid, but you got to declare it in the country, because otherwise, and let's say the one plaintiff could be a whole state. So otherwise, it's crazy. If somebody goes to crosses state lines, they won't be anymore. Or if I cross state lines, I won't be. And the whole thing, it would be completely chaotic and unsettled unless you make a nationwide ruling, because that's what you need to do for complete relief. So the 2 kind of openings that the court has left: class actions and complete relief. And then failing that, just blitzing the courts. One big thing about class actions, which, as I say, is definitely where litigants are rushing in now to try to work around the nationwide injunction ruling from last Friday. At least Alito did a separate opinion in that case where he said to district courts, now don't let litigants snatch victory from the jaws of defeat and just turn and do class actions here. So he's clearly going to be against it. Justice Thomas, who joined him, is clearly going to be against it, and he's actually admonishing lower courts not to permit it, which is kind of a good one, because the opinion overall, one very strong theme is, disrespect for lower courts and saying, you can't do this, only we can. And also ignoring, as they did in this very case, the administration having really jerked around the lower courts. You would think the Supreme Court would have their back, but no, much more has the administration's back. But anyway, we need to be prepared for a couple members of the court, and maybe 5 or 6, actually saying, oh, you're smart idea litigants, just do class actions. For whatever reason, we're going to tighten up the standards on class actions, or in some ways limit them when you're challenging executive orders. It's just not clear. But that's the basic menu now. You have this decision from last Friday that could be a colossal body blow to the cases that have succeeded again and again and again. And by the way, the reason they have, the Trump administration complains to the Supreme Court, they do it to us so much more. And they say to the people, it's because they're Marxist crazy, blah, blah, blah. And there's a clear reason why they succeed again and again. It's because the administration has again and again issued unlawful and often unconstitutional executive orders. But so now that the nationwide injunction is not an available tool, litigants will turn to these 3 strategies, but especially, and the thing to keep our eye on immediately in the next month or 2, not just at the lower court level, but how the courts of appeals handle these efforts, is the movement to convert what they had before into class actions with very large classes, such that giving relief to everyone in the class is pretty much tantamount to a nationwide injunction of the sort that the court has said lower federal courts may no longer enter. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.